Hello, how are you today? I hope you are fine and I hope you are doing good. So these recordings is on capacity of infants. So we already have one on childhood. So we already have one recordings on capacity of an illiterate, and that of corporation and federal governments and their agencies. So this one is basically on capacity of an infant, capacity of drunkards, and capacity of persons of unsound minds. I would advise that while you listen to this, okay? I would advise that while you listen to these recordings, listen to it as if you were in a class with me and ensure you are jotting all that is needed, all right? This will facilitate discussion in the class and helps us to clear all gray areas, okay, during the time of questions and answers. The purpose of this is to ensure that the class is for clarification of terms, is for understanding of the terms, so that we don't take time, the lecturer will be there talking and the student will not get feedback. I will not get feedback from you, neither would you get clarifications, all right? So ensure that you're jotting it down and do that, ensure you listen to this before the class, okay? So capacity of an infant. Under the law, you can either call them an infant or a minor, okay? So an infant, basically, you know, in a normal term, we call those that are infants are those maybe below the age of 1 or 18 months in the dictionary meaning. But in legal terms, we term those between a certain age where they haven't gained maturity. We call them infants, all right? So if we want to say who then is an infant under the law, I've explained who, according to dictionary, the normal term, an infant is anybody, you know, children, babies below 18 months or a year. But under the law, who is an infant? No, so to start with, the definition of an infant under the law or a minor under the law varies. It depends on the circumstances in which you are looking at it from, or the subject matter. For example, we are going to be looking at the circumstance of a criminal liability, of marriage age, of voting age, driving, the ability to be able to be driving, religious, be able to participate or do something in a religious setting, and also when it comes to cultural context. Now, under the National Child Policy of 1989, it defines a child as anybody who is 12 years and below. Okay? The voting age in Nigeria is 18, you all know. And in criminal liability, it is in two categories. We have child as anyone below the age of 14, and that a young person are those between the age of 14 and 17. Okay? That is for other subject matter. But our focus here is on contract. We are on the law of contract. And so contractual, we are going to be talking about contractual liability of an infant. So contract that is made by an infant, they are governed by the rules of common law common law. And also common law has been before now, and also is still also present how the judges decide cases and all of that. So it is governed by common law, all right? And it's also governed by the Infants Relief Act of 1874, all right? The common law has been altered by the Infant Relief Act of 1874, wherein a child is said to be anyone below the age of 21 years. We are talking about the year 1874, all right? Now, the age of maturity, which was formerly now 21 years, under the Infant Relief Act of 1874, has been reviewed, all right? It has now been reviewed in Britain, and that has been done before we reviewed ours in Nigeria. In Britain, it has been reviewed for a long time to 18 years. Because it has now been discovered that persons between 18 and 21 has now been seen to be involved in a lot of commercial transactions. And you really cannot deprive them of that because they seem to be getting hold of it. All right? If you go to, even going online, even not really online, people after they had left secondary school, they have been involved in especially those that are unable to proceed in education. You see them going into businesses after they are done, maybe they have done any form of training that can enhance their capability to do one thing or the other. You see them in businesses. So the question that comes to mind then in Britain is, can we then keep depriving this set of people, even with them having the ability to understand the circumstances of the commercial transaction they are involved in, all right? And that is why it was so in Britain. 18 years and below has now been used as a cap. Now, subsequently, in the year 2003, Nigeria, under Section 277 of the Child Rights, adopted 18 years also as persons, 18 years below, as persons that can be referred to as minor or infants. Now, you need to understand and also have it in mind, take note, that not all states in Nigeria has approved of it. Now, we only have 34 states in Nigeria that has approved of 18 years below as age of minority. States like Kano and Zamfara hasn't reviewed their own Child Rights Act or their own Child Rights Law as complying with the Child Rights Act. All right, so they haven't done any of that. So in the case of Folata against Dowoma, all right, it's a case where a youth sold their family house. In that case, all right, we call it a youth, in that case, it was held that under the Muslim law, now this is for you to correlate the issue of Kano State and Zamfara not complying or not making this law 18 years as a clause or as a cap for them. Because under the Islamic law, maturity basically and not totally is not determined by age. It's determined by their physique. If they have matured by bringing out all those physique that make one look matured. And so in this case, it was held that under the Muslim law, maturity is determined by physical development or declaration of the youths in question, all right, or by reaching the age of 15 using the lunar months. In this case, now, so explaining this, a child or a person needs to have, if the person has shown in their physique, if it has shown in the physique of a person that they are now they have all the things that makes them mature. Like a man now is like, if a male is huge, has broad shoulders and all of that, it shows that they are mature. But in the case of a lady, it has shown all the things, all the physique that it needs to make it look as if, especially puberty, when they have shown all that is needed to see that they are mature, all right? Also, whether you declare or where that person declares outrightly, openly that, oh, I am a youth now, all right, with all the physique that has been shown and all of that. And the last one being that if a person has attained the age of 15 using the lunar month, now the lunar counting, is I think is between 26 days, 25 or 26 days. Unlike our the English calendar month, which reads 30 or 31 days or 28 days in terms of February, all right? But for the lunar month is below 30 or 31 days. And so if a person counting their age using the lunar month attain the age of 15, such a person will be seen as being matured. And that is the reason, or if there's any other reason we can discuss in class, that is the reason why Zamfara and Kano will not align with the Child Rights Act. So also in the case of Labinjo and Abake, there was an argument that contractual capacity in Nigeria should be when the person attained puberty or physical maturity. That argument was rejected. Now, the argument that was agreed to or that was propounded in 1970 in the case of Folata and Dawuma, that argument was refuted in Labinjo and Abake. That means that when a person has reached a maturity, that they have matured in terms of they've attained puberty age, this case refutes it, and this case upheld that it should be 21 years. Remember, 1974 is before the Child Rights Act of 2003, all right? So initially before the 2003 Child Rights Act, it was 21 years. Subsequently, after the Child Rights Act, in these 34 states that are not Kano and Zamfara, puberty, or would I say infant or a minority, as anyone below the age of 18. That being said, now I'll send some questions which will include this kind of question where we are going to do a form of debates in class. So I want to know if this reduction of Britain or even Nigeria, reducing from 21 to 18 years, do you think is beneficial? Or do you think it should be prejudicial to a child? So will you advocate a further reduction? Should it be 15? Like the case of Folata and Dowoma? Or should it even, because of computer now, or should it even be higher? Should they go back to 21? Should it be 24? Or should it be lesser than 18? Now, I want you to have this in mind, that when we are talking about minor, the reason why the court tries to protect them is not just that as a matter of they are not being attained majority alone, or that they cannot think, or would I say that they cannot make logical conclusion regarding some certain subjects. For example, in the case of landed properties and so on. Another thing the law looks at is their experience. A lot of the times they have not gained the experience that would enable them make some decision regarding some form of contract. For example, landed property, acquiring land or any other thing. All right. So we are going to reason all this in class. All right. So going forward, let's look at the statutory framework. All right. What is the statutory framework regarding children, infants? The child rights law of several states, for example, let's use that of Lagos State. Section 18 provides as follows. All right, that any contract except a contract for necessary entered into by a child for repayment of money that they lent or for repayment of goods supplied to the child shall be void ab initio. No action shall be brought against a child by a person after the child has attained the age of majority to pay a debt contracted before majority or ratified or minority or any promise of contract made by the child before majority, whether or not there was a new consideration for the promise or ratification after the child has attained majority. Number 3, or would I say subsection B of section 18B, 18.3. If a child who has entered into a contract for a loan, which is void, agrees after majority to pay the loan, all right, the agreement is in whatever form it may be, shall be void ab initio, so far as it relates to money, which is payable in respect of a loan. So as we go along, you get to know that a child or an infant cannot borrow. All right? When they borrow, it is deemed as being void. All right? So subsequently, let's keep going to, so we don't take time. So that is it for the child rights law. So let's look at the infant law, the infant's law. We have 3 types of contract when it comes to an infant under the infant's law of the Western region of Nigeria. That's in 1959. You know, in those days, we normally have the Western region, Southern region, Northern region, and all of that. All right. So this Northern region, Western region are states like Lagos State, Osun, Oyo, Ogun State, Ondo, Delta, Ekiti, Edo, and so on. So these are the contracts that are deemed that are mentioned under the infant for infant or for minorities. Number 1, contract of loan. It is void ab initio. Contract other than necessaries. Any other contract that is not a necessary. It is also seen as void. Okay? As we go on, you get to know what void means. What do we mean by necessaries or non-necessaries? The third one is account stated. Anything that has to do with account stated, like IOU, is also void ab initio. All right? Account stated can simply be defined as an admission of obligation to pay a definite sum of money in certification of a loan. Remember our section 1, we are referred to a loan. All right? So I want you to also note, all right, that statutory provision takes precedence over common law, all right? While the most recent statute may be deemed to have impliedly repealed the earlier one, subject to the rule that special statute will override the general in the case of conflicts, all right? So if there's any rule, if there's any new act which is not which has reviewed the infant law, what I'm saying, what this place trying to say is that it will override. But then the one that we are using in this context, we are using the infant law. All right, we are using the infant law of the Western region. Okay. So after we have looked at the statutes as a statutory provision, what then is the provision under the common law? All right. So under common law, we are going to look at it in 3 different phases. We are going to look at contract for necessaries, for non-necessaries, and voidable contracts. All right. So what are necessaries? What are contracts that are for necessaries? So it has been recognized from the earliest time that an infant is obliged to pay a reasonable price for necessaries. Okay? So necessaries, they are goods that are suitable for the condition in life of the infant. They are goods that are suitable to the condition in life of an infant and to his actual requirement at the time of the sale or when the item was delivered to them. Okay? Justice Anderson gave a better explanation in his decision in the case of Capul against Cooper, and this is what he said. He said, necessary are things without which an individual cannot reasonably exist, depending on his status and condition at the time of sale or delivery. I keep mentioning delivery. That is to tell you that when something has not been delivered, even if it is necessaries, an infant is not obliged or is not enforceable on the infant. So the meaning of necessary is not confined merely to bread or to clothes, to shelter, but also to education. And so necessaries are like something like bread, your food, your clothes, your shelter, even education. All of these, they are going to eventually make life suitable for an individual. Okay? An individual cannot exist without food, without shelter, without clothing. And in fact, an individual cannot exist without having something. Education will eventually is a training that eventually puts you into a position of employability. And so without education, it is deemed as if an individual may not have a proper future. All right? So a word which in this connection extends to any form of instruction that is suitable for the particular infant. Also some form of services, some form of beneficial services, or when you are learning a trade or something. So, sorry, when you are learning to become like something aside from education, all right? Those are also beneficial to the infant. So, for purposes of convenience here, contract relating to education will be treated under beneficial contract of service. All right? When we get there, we cross it. All right? I also want you to know that whether goods or services are necessary, whether you say, oh, these goods or the services this person is giving or is being given, if they are going to be necessary, it is mixed between it being law and being fact. It is it's a question of mixed law and facts. Okay, so listen. So the preliminary question of law is, number one, whether that good or article is capable of being a necessary. And we have mentioned according to the law now, according to common law, to what we have learned under Chapel and Cooper, we learned that necessaries are food, shelter, clothing, education. So when you see all of these things, you know they are necessaries. Now, the fact that these things are necessary doesn't limit it at that. You also need to look at whether the goods or services is necessary in the circumstance in the particular case. All right? The fact that something is shelter or clothing doesn't mean that at that time is necessary to that time, to that child. You get to know according in our discussion that if an infant already have 20 clothes, 20 particular clothes, maybe it is meant for your school, for you going to classes. That infant buying additional 20 or additional 2 or 3, the additional 3, you get to know that they are not necessaries anymore. And they may not be liable to pay for it. So the circumstances also matters, not just it being a necessary. And so that's why we say it's a mixed law of, it is mixed. It's a question of mixed law and fact. So law must be seen evident in it, and also the circumstances, the facts of the necessary circumstances will also be put into consideration. So let's now look at the onus of proof. So the onus of proof lies on the party seeking to enforce a contract against the infant. When an infant refuses to pay for necessaries or for anything, it is not in the position of the infant to prove that I'm not supposed to pay. It is the person that wants that money or that thing from them that sue them to court invariably that have to prove. They are the one that has the onus to prove that this person is not an infant, or that whatever I've sold to this person is necessary and they have to pay for it. So, for example, where the court decides that an article or good is clearly capable of being necessary, like food, clothing, lodging, it is a question of fact, whether they are necessary in the particular circumstance that I have explained. So the statutes actually require, and the status, number one, actual requirements and overall circumstance of the case must be considered before determining whether or not these articles are necessaries or not. And so, a rich man, for example, the likes of the rich men in Nigeria, we know them. We have some that are well known, you know. Those children cannot be wearing a Rolex, where they cannot want to buy a Rolex wristwatch, and you question them, or you say it's not a necessary. For people that are very rich, I don't want to mention names now. For the very rich one in Nigeria, example, Rolex will be seen as a necessary, as against a gentleman or a student or an infant whom their parents basically are traders, people that are buying or selling on the streets and just managing to ensure that their children are well fed. That is not to say that, you know, but the thing is, you need to look at the life, the family life of that person. Oh, would the parent of this person be capable of buying a Rolex? Will the allowance, the monthly allowance of this person be capable of buying a Rolex? You really cannot tell how much a rich man will be giving their children for allowance. Some of us, when we were in school, I could remember being sent 1,000 naira as allowance. And I'm not telling you that in those days, I don't have friends that are giving 10,000 naira as allowance. I have friends like that. And it's not as if they are very rich like that. They are average. So now talking in those days, I could still have friends that would have their parents giving them 100,000 as allowance. So the circumstances matters a lot when it comes to necessaries, okay? So I'm going to be giving you the case of Peter and Fleming. The court decided in this case that generally, it is not unreasonable for a minor undergraduate to have a watch and consequently a watch chain, all right? But the question whether a gold chain was reasonably suitable concept was an issue, all right? The court held that Peter, a minor with a reasonable social status, purchase goods, including gold wristwatch, which were argued to be suitable and necessary for his lifestyle because he comes from a from a well-to-do family. Okay? You cannot compare him to a person whom their parents are struggling or they are just trying to ensure that their children goes to school. If such a child buys a gold wristwatch, it should not be a necessary anymore. But in this case, a gold wristwatch that Peter bought was seen to be a necessary because of his social status. But in the case of Reader against Womble, it was held that a jewelry that was worth £5 and a goblet that was worth 15 guineas could not possibly be regarded as a necessary for an infant possessing the income of £50 a year. When you're talking about jewelry like a solitary, they're like jewelry that are made with like a single stone, like a diamond or a gold, all right, or a goblet. All these old antique, all this sum is seen very expensive for a person whose yearly allowance is £50. Remember, the yearly allowance will probably involve his feeding, his clothing, and all of that. How will the court in that decision decided that these things that he bought, buying an antique goblet is like a cup, an antique one, and a jewelry, more or less, that's made from a very priced stone like gold or diamond, such to him is seen as being not a necessary. And I'm sure if he was to come from a place where he's being given maybe like £5,000 in a year as his allowance, it will be seen as necessary for him. So I want you to understand that necessary is also not just a matter of law, strictly, it's also a matter of fact. Has to be in combination. It comes together. You have to look at it together. The court considers it together. So if the things are capable of being necessary, the fact that the infant is already sufficiently provided with the things of that kind will make the price unrecoverable, even though the other party does not know this fact. All right? And so what this is trying to tell us is that even if what that person has bought, what that infant has bought, is actually a necessary, but the fact that he has a lot of that thing already will not make it a necessary again. Or can we say you cannot recover the money from the infant if the infant has refused to pay? And so in the case of Nash and Inna, in this case, was an undergraduate just like you in Cambridge. He already have some clothes already. Okay? But then he went ahead to buy 12 fancy waistcoats, whereof his parents has already provided that for him already before he left home. But on getting to the university or to the tertiary institution, he went ahead to buy 12 fancy ones that cost him 2 guineas. Guineas are like more than £1, all right? So when they calculated, it was £122, 19 shillings. And so his father has already gotten that for him before. So when Mr. Nash, the owner of the place where he ordered for those items from, when he claimed for his money, the decision of the court was that this man already have enough. Buying additional one to him is not necessary enough, and you cannot recover the money, even if you didn't even know that he has at home before. All right? So this begs the question that what should be the duty of the owner of an establishment that wants to sell something that is non or anything whatsoever to an infant? So you have to be careful And this will be your advice to people like this, that you have to be careful with your business with an infant. But then under this, we have two issues that we are going to discuss, all right? Issue one, it is very important that you know that an infant is obliged to pay a reasonable price for necessary goods and not the contract price, all right? So invariably, what this is trying to tell us is that you cannot hike the price for an infant. So when they give you an amount that is actually very okay, you should be able to take it, even if it's not the contract part. But then you will see that there's been argument relating to this. So if the contract price is outrageous or is arbitrary, the court could reduce it and ask the infant to pay what is considered to be reasonable. So if the normal rules of contract were to apply, the infant would have been made to pay the agreed price, whether it's reasonable or not. This is like the argument that is being that comes up from it. If we want to use the rules of contract, when you contract for something, you pay for it. When in your contract, there is offer, acceptance, consideration, you pay the consideration. You don't go tomorrow and want to review the consideration. You look at the rule of Equitable, all right? You cannot review the consideration. That is what the general rule of contract will say. All right? Another issue we have is that we have two conflicting theories. Two conflicting theories have been advanced as the basis for the minor liability for necessary, for minority liability for necessaries. One of the theories is said to be liable just as a contracting party of full capacity is liable. All right. So another two is said to be liable not as a consensus, that is not because he has agreed, but because he has been supplied. And so when you are looking at the rule, you know, this is another issue, all right, that we are considering. And one of the issue here is that an infant, when he enters into contract of necessary, all right, is seen to be capable just like an adult will be capable. All that an adult is expected to do, you're expected to do as a minor as well. Another argument or theory under this is that the fact a contract that is entered into with an infant is not a matter of consensus. It's not a matter of the fact that, oh, you agreed or not, but it is a matter of being supplied. If he has agreed to a contract of necessaries and he was not supplied, and subsequently he said he's no more interested again, you cannot sue him for what has not been supplied to him, even if he has agreed to it, even if there was a consensus. But immediately that thing has been supplied to him and he has received them, he will be made to pay up or it will be enforced against him. So please do not forget this. You may want to listen again, all right? Listen to it again so you can understand. So going forward, we'll now look at these arguments, all right? What has been the argument on these issues that we have raised earlier? One is that the first theory that we raised has been faulted on the ground that an infant is obliged to pay a reasonable price for the necessary, not the contract price. Remember, in our issue, we have been made to understand one of the first issue, that when an infant enters into a contract, is meant to pay a reasonable amount. He may not actually pay a contractual amount. And so the first argument has been faulted with that. So if a normal rule of contract were to apply, the infant will have been bound to pay the agreed price, all right? But then under the infant would be allowed to pay or will be made to pay the reasonable price. You know, all of these things comes up whenever there is a question in courts. So an infant cannot be going around doing whatever they like. It's only when they get to court that the court start deciding and all of that. Regarding the second theory, the question whether an infant is liable on an executory contract for necessary is debatable. So that is what we are saying in essence is that on saying, oh, when the contract has been supplied, has been delivered to them or not. No, I said when it has been delivered to them, it is deemed as if they will pay. But if it hasn't been delivered to them, they are not meant to have to pay when they say they are not paying. Now, this is as a question. It comes up that what if it is education? Remember that in education, you pay before you start your academics. So the question is, can you now come tomorrow and say, oh, I don't want to go again. I'm not going ahead with my academics again. I want to collect my money. The law says that is not the case when it comes to education. All right. So if the obligation arises that an infant clearly cannot be liable for goods not actually supplied and presumably is refusal of them when tendered is justified, it is difficult, that is it for that. So it is difficult to find a case where an infant has been held liable without actual delivery of goods. All right. So we have not really have a case where an infant is has been held liable without actual delivery of goods. And it is safe to assume that an executory contract is not enforceable against an infant. All right. An executory contract is not enforceable against an infant. It is more difficult to determine the basis of liability where the subject matter is not goods. That's what I'm trying to explain. That is, but when it comes to goods, when it is executory, when it has not been supplied, you cannot claim. All right. But when it has to do, for instance, a contract of lodging or for education, when you rent an apartment as an infant, or in the case of education, what obtained in the place of goods doesn't obtain in the case of education. So in the case of Roberts and Gray, the defendant, who was an infant, he desired to become a professional billiard player. And so he made a contract with Mr. Roberts, and he's a leading professional in that aspect. And the parties agreed to accompany each other on a world tour, and they wanted to play matches together on different countries. So Mr. Roberts has gone through a lot of expenditure trying to prepare for their tour. In fact, he has used a lot of time. He has gone through a lot of trouble to incur some liabilities, making sure that everything that they need for the tour is ready. And he had done the preparation. So there was a dispute amongst them. All right. And so before they go ahead for the tour, there was a dispute. And so the defendant, who was the minor, tried to repudiate. Repudiation means I don't want to do again. Try to refuse. Try to refuse or say he's not going ahead with the contract again. Mr. Roberts subsequently sued the minor, Gray. He sued him for breach of contract. In the defense of the minor, he said that he had repudiated the contract while it was still to a large extent executory. And so to him, we have not started on the tour. We have not commenced the tour. And so it is still executory. And so that he has repudiated it during that time. And so he's not liable. All right. The court decided and discountenanced the arguments of the minor. And the court held that a contract does not cease to be binding merely because it was executory. So the fact that it was executory, especially in this kind of contracts of services, of education, trying to, you want to be a professional, you went to a profession, and this person will be helping you, training you. In that case, you cannot say it is executory, all right? More or less, you always have to pay in advance for things like this, all right? So, according to the decision of the court, unless the decision of Mr. Roberts and Gray can be discounted with on the ground that the contract had been partly executed. It should seem to be an isolated case contrary to the principle that an infant is not liable under executory contract, all right? So the solution lies in separating the contract for education from categories of necessaries and bringing it under beneficial contract of service. And so in trying to ensure that the decision of the court in Roberts and Gray doesn't seem absurd or is not in contravention to contract of goods or necessaries. So they decided to differentiate it, saying that contract for necessaries and contract for beneficial services. And so for contract or a beneficial contract of service, executory contract is approved, is acceptable. For example, when it comes to education, or that the person is in a service which will be beneficial to them. You know, in Grace's case, it would have to be going on top with Mr. Roberts. In that case, he's working for Mr. Robert and as well being trained by Mr. Robert. So is a beneficial contract of service. So we have concluded now that beneficial contract of service is binding, even though it has not been completely executed. That has been agreed. So also significantly, that all authority that has been relied upon by the court in the case were concerned with beneficial contract of service. And so anything beneficial contract of service, when it can be executory in nature, all right? So that is it for contract of necessaries. You now know what contract of necessaries are. You know what the rules are when it comes to contract of necessaries. You know that it should not be exam, especially when it has to do with goods. After we have been able to differentiate them, it cannot be executory. All right, it must have been executed. All right. So looking at beneficial contract of service, it includes, in cases of apprenticeship, employment contracts, all right, when an infant is employed for some services. You know, at that time, he's employed and so he's making money from it for their home benefits. So such contracts may be essential for a minor to support their physical developments through training in trade or arts, or to earn a living through employment, or for them to earn a living through employment, all right? So all of it is just for them to benefit from, okay? So beneficial contract of service has to do with physical development through training, which can be in education, like line like this, or in apprenticeship, or for them to earn a living. So a beneficial contract of service is valid and it is binding on an infant if it is substantially for his advantage. All right? If it is for his advantage. And so when you are saying that, number one, education is for your advantage, it's for you to become a better person in the future. Apprenticeship is for the advantage of the minor who has gone for apprenticeship, because it's going to help the person to become a better person in the future. But then it is binding on them if it is substantially for their advantage. All right? So a beneficial contract of service, especially in place of employment, should not be that will be depriving the child solely, and the child will not be able to benefit from it. So the mere fact that one or more of the terms of the contract are prejudicial to the infant is not decisive. And so as a matter of fact, some terms are not directly beneficial to the apprentice or the employee. Those terms must be expected in all contract of, they are expected in all contract of apprenticeship or employment. It's not all terms that are beneficial to them. Some will be beneficial to the employer and some to the employee, all right? But then it should not be one that will be so outrageously unfair on the employee who is the infant. So the court has carefully examined all the terms and weighed the erroneous terms against beneficial terms, and then decided whether the balance is in favor of the infant or not. So whenever the law is deciding on cases like this for beneficial contract of service, especially in place of employment and all of that, the court try to weigh whether it's in favor, it is balanced, whether whatever their terms are is balanced in such a way that the infant will also benefit from the contract of service, all right? Okay, so the court will uphold a contract involving an infant only if it is evident that the agreement is reasonable. The reasonability of the agreement is customary, and that it is beneficial to the infant. Now, in the case of the France company against Ban, and the case of Clements and London North Western Railway. So these cases are very unique. For the case of the France, this was a case of, okay, I think I should use this. I also have it in this slide also, but I think it's good I've used this. This one seemed clear for me. So in this case, this is a case of a 14-year-old young child who signed an agreement with a dancing firm or something that is going to be learning dancing, and also you'll be working for them. You'll be dancing for them. And in the process of dancing, you also learn on the stage, all right? So the agreement, their terms was extremely one-sided, all right? So the terms reads as follow. Number one, that she could only marry or take other jobs with the permission. It has to be with the permission of the owner or the employer before she can get married or take other jobs like dancing or any other jobs, all right? Another is that the employer, who is the master, didn't have to guarantee her any job or any other payments during her employment, all right? Whereas, she's supposed to also take her out on some other dancing tour so that she can make money from it. But there was nothing of such. There was no agreement, or there was no guarantee regarding that. The other term is that the pay she will receive is very low, like 9 pence per night. The other term is that the master could end the contract at their will, but then the infant cannot end the contract at their will. And so the position of the court was that the terms of the contract here is unfair because the child was completely at the mercy of the master. And so in this case, although it's a beneficial contract of service, which is binding on the infant, but in this case, it is not binding on the infant because the court saw it as being unfair on the infant. But this can be contrasted. You can contrast it, with the case of Clements against London and North Western Railway Company. Is Western Railway, okay, company. Let me just speak. All right. Okay. So the situation in this is that an infant works for a railway station, and as terms of their contract, she agreed to a joint company specific insurance plan. She gave up her right to sue the company for injuries under the standard law. All right. When there was an issue, the infant sued the railway company to the court, saying that the contract of service, especially that of insurance plan, was unfair and that is not binding on him. The position of the court was that that insurance plan was even for his own benefits, and it's going to benefit him if there's something of such. So in as much as he's enjoying with the railway has employed him to do some things, and everything to the court was said to be, so the insurance plan was actually better for him in cases of accident and all of that. And so the court decided that the deal is whole and its benefit for the young worker. And so his claims was dismissed as against the Northwest Railway Company. This is to tell you that when it comes to a beneficial contract of service, it is binding on the infant, all right? But then, if it is unfair, if the terms is unfair, employment terms is unfair, it would be deemed as being not binding on the infant, all right? So this is another way, let's see if I can put in this. Okay. This is another version of it, explanation of it, but it's just the same thing. Although this one carries, you want to go and look for it in the library to have a broad understanding. You can use you can use this, all right? So moving forward, it is very important for us to know that for a contract to be a beneficial contract of service, it must either be a service or apprenticeship, okay? It must either be a service or apprenticeship contract, okay, that the person is rendering service or that the person is going under some training, okay? So in recent years, the courts have taken progressive wider view of what a contract of service is, all right? So in the case of Doyle White City Stadium, an infant boxer who was working with the British Boxing Board of Control, which the essence of him working with them was to get a license, or, you know, having a contract with them for license was also seen as contract beneficial, is a beneficial contract of service. Even if the contract doesn't have to do with him doing anything, but just to get a license from them, it was regarded as beneficial contract of service. Also, an infant pop-up group, when they employed a manager, them employing a manager was also seen as a beneficial contract of service. And when it was sued to court, you know, the case was seen as that the contract was valid as against the infants. But it has been established over a lot of years now that anything that has to do with trading is not a contract of service. Trading like buying or selling, like an infant buying and selling, you know, buying something from somebody and going ahead to sell those things. That is not seen as beneficial contract of service. It is seen as trading strictly, and it's void. A child, an infant, should not be seen as doing such, like trading. So trading is not binding upon the infant, no matter how much it is for their benefit. Even if maybe when they are that trading is for them to benefit from it, all right? It doesn't, it's not categorized, or it's not okay to be seen as beneficial contract of service. Now, for better explanation, you should look at Conwan and Nerd. The case of Chaplin against Leslie Rewell, also the case of Abinjo and Abake. That's a very good case. Remember, we have mentioned the case of Abinjo and Abake. In that case, anyway, when we get there, we are still going to do something on that. In that case, Abake bought some items. She was around, this was a case of, is a 1975 case, I guess, before our law, before the Infant Relief Act and the Child Rights Law. Before all of that, Abake used to buy and sell, and she buys from Mr. Labinjo. And so at this point, she bought some items on credit, and she was unable to pay. They have requested from this money from Labake, but she was unable to pay, claiming that she doesn't have the money. So Labin just sued Abake to court. the position of the court was that Labake was still 18 years, which was under the, if you can remember, the common law, the position of the common law there, that any child below the age of 12 years, 21 years is seen as an infant. So in that case, the court decided that Labake was still an infant and that she cannot be seen to be trading. Now, this is another question we are going to answer in class tomorrow. In attempting to rationalize why trading contracts are excluded from beneficial contract of service, what relaxation, if there any, will you suggest? Because even till now, even till date, anything that has to do with trading is still seen as void, not acceptable. So I want you in court, in class tomorrow, we are going to be debating it. Do you see it as too strict? Do you think that it should be relaxed? If it should be relaxed, what should be the content of the terms of the law if it should be relaxed? Another question to be determined on beneficial contract of service is whether an infant is absolutely bound by the terms of such contracts or whether he is only bound to pay reasonable price. Remember that we mentioned something earlier about if it is okay that because it's an infant, it should not abide by the contract, but then there should be a reasonable price. The question is, do you agree with it? Should an infant be absolutely bound by the terms of contract, or should it be bound to pay a reasonable price as it has been so far, as we have agreed? So there's actually no direct authority on this issue. It is submitted that the contract should either stand or fail. In as much as we are going to talk about it, the court should not have the power to adjust terms of contract because that would be unfair on the person who had contracted with them. Certainly, if the terms are substantially unreasonable, then it cannot be for beneficial to the infant. Hence, the infant should be free to repudiate it in its entirety. So it should either stand or fail regarding the fact that if it is nice or if it is not good. All right, so I think I've done something. I may have to go back on this. Okay. Okay. So that was a little H from my side. Okay, moving forward. So that is it for us, trying to know whether an infant is whatever. So what I just try to do here is that if we want to decide on whether an infant is absolutely bound by the terms of contract or whether it's only bound by reasonable price, we have to, it should be a matter of it being fair, all right? Was it reasonable? Was it a reasonable price? Was it a reasonable contract when the court has seen it? If it is reasonable, then the court should not touch it. But if it's not reasonable, then the infant can actually repudiate, okay? But then I will seek for your opinion tomorrow in class, just to be that we are together. So this is the third one. We are looking at voidable contracts. We have looked at necessaries. We have looked at beneficial contract of service. Number 3, we are looking at voidable contracts. So this is actually another category of contract that an infant acquires an interest in some subject matter of permanent nature. For example, buying shares or to lease a property. All right. So in this type of agreements, it imposes on the infant it imposes some duties and obligation on the infant and also some benefits on him. So such contracts are not treated under beneficial contract of service because they do not relate either to employment or apprenticeship. And so these contracts are can be repudiated, but then we call them voidable contracts. That means he can decide tomorrow to say, I'm not going ahead again. All right. So the principle is that such a contract are actually valid and they are binding upon the infant, unless he repudiates them during his infancy or within a reasonable time that he attains majority. All right. So the meaning is that these contracts of shares, buying shares in a company, the company share being a part of the company, buying shares, or where he leases a property, all these things are binding on him. But at a point, he can decide to repudiate the contract at any time. Repudiation means he's saying that he's no more going ahead with the contract again. He wants to opt out. He can opt out at any time. We also call it to rescind, to say that I want the contract, or I want to go back to the position I was before I entered into the contract or before I was involved in the contract. So, except he does that, the contract is still valid. But immediately he does that, it's not valid again. He can also repudiate it, all right, within a reasonable time after he has attained majority, all right? So when a child reaches the age of 18, he can actually still repudiate it within a reasonable time. Now, the question of reasonability can only be determined by the court of law, all right? So we've not had a case where the court, common law or anything has given us an instance of it. So at common law, all contracts for non-necessaries are void. Anything that are non-necessaries are void. So contracts are said to be voidable since it remains valid and is binding until the infant rescinds it, until the infant repudiates it. So there are no such principle at common law that all contracts for non-necessaries are void. So when you say something are not necessary, it doesn't mean that they are void. It means that some can be voidable, but some can be outrightly void. So the ones that are voidable are this example: acquisition of shares or lease of property. But there are some that they are outrightly void. I have given you example of trade. When an infant is involved in a trade, it is outrightly void. That means there is no remedy. It's not valid. It's not binding. All right. So A contract of the class that we are now considering, which is the voidable contract, it does not require the ratification of the infant when he attains majority to be binding, as it remains binding upon him unless he repudiates it after he became of age. So there are some certain contracts that he can ratify. That we are going to deal with that when we get there. So according to the case of Edward and Carter, if an infant chooses to be inactive, his opportunity passes away if he chooses to be active. The law comes to his assistance, all right? So if after he attains the age of majority, he quickly repudiates it, the law will protect him. But if he went to sleep on his right and did not do anything, and after a lot of years, he now comes back to say, oh, but I did it when I was a young child. But the court will say, you ought to have repudiated it. But since you didn't repudiate it, it's deemed as if you agreed to it, okay? All right. So it is perhaps assumed that an infant, upon reaching the age of majority, discretion is expected to appraise his obligation and benefits under the contract, and it comes to a firm conclusion on whether to repudiate or allow to continue. And so it assumes that whenever they reach that age, they have the discretion to either agree or not to agree to go ahead with the contract. So when the infant chooses to repudiate the contract, he must do so within reasonable time after it comes of age. So I have said that what is a reasonable time depends on the fact of the case. And so in this Edward case that we have said above, 3 years was seen not to be a reasonable time. It was held to be too late. 3 years, more or less like when the person attained the age of 21. Okay, like 3 years after it became 18 years, then that would be seen as not within a reasonable time. So what then happened? What is the meaning of repudiation? What is the effect? When a child repudiates a contract, when a child says, oh, or when an infant says, oh, I'm not going ahead with this contract again, what happens? What's the effect? So repudiation of a contract relieves the parties of a future obligation. All right? So what it means in essence is that going forward, I'm not doing this again. The obligation, I don't have obligation in this contract again. So in the case of Stenberg against Seal Leeds Limited, while it was actually certain that the repudiation of a contract in which an infant acquires an interest in subject matter of a permanent nature terminates the future obligation of the parties, there was a question as to whether the infant was free to honor the obligation on his own part after he has accrued some obligation which he did not do. Does it mean that if an infant repudiates a contract, all the obligation that he has refused to do during the time of the contract, does it mean that that too will go with it? So let's say, for example, if an infant repudiates a lease and he has not actually paid rent that is due to him, does it mean that he will not pay the rent again? And so we really don't have a direct authority that says he should not pay the rent or that he should pay. But then we have two views, all right? The first is that repudiation is in retrospective. So what it means is that, retrospective, it means that if a child, an infant repudiates a contract, it is deemed as if he was never involved in the contract. And so it is deemed as if nothing had happened. So which means he has rescinded, there is rescission, that the contract will be deemed as if he was never involved in the contract. So that is, it terminates the contract and put the parties in status quo, that it restores them to where they were before they were in the contract. And so the position in which it stood before the contract, and so there was a decision to this effect in the case of Park B North Western Railway Company against MC Michael. So the question that comes to mind is that the principle that was stated in the Part B was that repudiation of voidable contract by an infant has a retrospective effect. And so it has not been universally acceptable. All right. This decision in Part B North Western Railway Company has not been acceptable when you are saying it should be in retrospective. And so look at the example that we gave, that a person or an infant who has leased a property, after he leased the property, he hasn't paid his due for some time now. And so it's time to repudiate now. Does it mean that he won't pay the due again? The dues, the rent that has been due? Does it mean they won't pay again? In the case of Part B, North Railway Company, the court's decision there is that he should not pay. But there have been uproar, there have been arguments, there have been opposition regarding this situation. And in the case of Blake against Contractual, an infant tenant, after occupying a premises for nearly a year with quiet possession and attaining full age, he tries to repudiate the tenancy. All right? He was held to be liable for not paying. He was held to pay the half rent which he has not paid, which has become due while he was in possession. Can you see that in this case, the case of Part B was decided in 1850, and the case of Blake was decided in 1870. After the opposition, the uproar, after the discomfort that may have happened over the years, that it should go in retrospective. If it goes in retrospective, then infants will just be doing whatever they like. They will rent an apartment after spending a year, after they hadn't paid, staying there for years. They can come tomorrow and say they will not be paying. And so the law has been in such a way, has revealed that term in the case of Blake and said, no, you have to pay what you have not paid after you have been in possession of that. So in view of these opinions that we have seen in the case of Part B and the case of Blake, it will really be misleading to say that the authorities have reached a definite conclusion upon this matter. So therefore, it will be advisable for you as a student to understand that the other party, it will be good for the other party to ensure that an infant fulfills his obligation as the false deal. So the right of the party to claim for the accrued obligation may be dicey. So if eventually the infant repudiates the contract, there is probability nothing you may not make it. So if you have this kind of case, let's assume there's a case in your exams that an infant tries to repudiate a lease. You have to, your argument should be in two ways. Your argument should be for Parker's case and also Blake's case, where you'll be able to explain the fact that, oh, these are the things that has been happened, but there's no decisive decision yet. And so it will be good on the part of whoever that leases a property to an infant to ensure that the infant is paying as at when due, so that there will be no issue in the future. Also, we are still in the effect of repudiation, all right? The question on the effect of repudiation is whether an infant can recover money. Now, we have talked about whether the person whom the infant has contracted with can recover from them. We have agreed to that. It is dicey. It is in between. It can either recover or not recover according to the two cases. But let's now look at the case of whether an infant can recover money which he has paid or property which he has transferred to the other party after he repudiates. So the rule is that the infant can only recover the money or property if there had been a total failure of consideration. So let's assume that an infant bought something, bought shares, but that over the years, he has not been paid his there has not been accrued interest that he has been paid. With that, you say there's no consideration for his contract. And so in that case, he can repudiate. He rented an apartment, but he has never lived in the apartment, or he leased an apartment now, using the words of our documents. He leased an apartment, but he has never lived in the apartment. Then in that case, he can repudiate, he can collect his money back because there has been no consideration. In fact, that will also be a question of this, of clarification in the court. All right. So the claim of an infant succeeded in the case of Kope against Overton, because at the time the contract was rescinded, the infant had not received any consideration for what he paid for. All right. So however, the test was not, in the case of Holmes against Block, this case is so very important that I've used this so much here. So in the case of Holmes against Block, it has not been satisfied. The test was not satisfied. In the case, this test of maybe the consideration has not been satisfied. It was not satisfied in these cases. In the case of Holmes and Block, and the case of Stenberg and Scaler. Okay, so the key point here is that the law does not ask whether the infant has gained a lot from the contract or whether he has received a rent advance. Instead, the question is whether the infant got nothing at all. So the thing is, does he even got at least something? Does he even get at least something? The question is not that maybe he got a little or he has stayed in the apartment for 2 days or 3 days. No. The question is, did you even get some consideration at all? Consideration can be little or not little, but it must be there. But when there is no consideration, the infant can recover. But in case where there is consideration, the consideration can be little and maybe large. The question is not as if maybe it's large or it's not large. The question is, did he get consideration at all? Did he actually get whatever he asked for in the contract? And so as explained by Younger LJ, the test is not about whether the infant gained anything real benefits, but whether the consideration, I mean the value that he was supposed to get, was completely failed. All right, maybe it has actually failed. So if the infant received what they had agreed to, even if the infant turns out, or maybe what they have received turned out to be worthless, the contract cannot simply be undone. This was reasoning. This was the reason in Scalar's case. Now, looking at this case, because if care is not taken, infants can just be, an infant that just got an apartment 2 months ago, can decide to say, I want to repudiate, give me the money. No. The issue is that, do you at least stay in that apartment? If you did not stay in that apartment, if the landlord did not allow you to stay in the apartment, that means you did not get consideration for your money. Then you can get your money. But when you at least stay in the apartment, maybe it's for 2 months out of the 1 year, then in that case, you have to go carefully. You are not going to get anything. It is either you stay there and not repudiate, or you repudiate and go with your repudiation. All right. So it has been seen that the rule has been unfair. And so since infants can make poor decisions because they are saying, oh, the rule has been unfair, although we are saying that infants should not make use of the law by saying, oh, we got an apartment last 2 months and decided to go today. There has been also some arguments saying that it's unfair because infants at times they don't make good decisions. Let's say, for example, an infant wants to lease a place. They may not know what to look out for. They may not know to wait for rainy season to ask for what happened during the rainy season. They may not know to ask that what is the security like. They may not know to ask that what is the lights, what is the power supply in this area like? Because as a student, you need these things often so that you can read and all of that, They may not know to ask of all these things. So that is the argument for some people that are saying this decision in Scalar's case is unfair. All right. So since infants can make poor decision or they can be influenced because of their age. They should be allowed to change their minds, to review their deal, and to cancel it without being held responsible. That has been the unfair situation. So the example in Holmes and Blogging, the infants should have been allowed to get their money back, especially since they backed out of the deal just one day after they turned 18. So the only reason the court didn't allow it was a technical rule about total failure of consideration. All right. So in the case of Holmes, let me just give you the fact of the cases here. It involves an infant who entered into a contract of lease during their minority, and made a part payment for the consideration. Upon reaching the age of majority, the individual repudiates the contract the very next day after 12 weeks of occupation. In this case, he had been in occupation for 12 weeks. And so he decided, and it was a day after he became 18 years. He sought to recover the money he has paid under the agreement. The court ruled that the infant could not recover the money because there was no total failure of consideration. At least he was able to stay on the property. So the infant had received the agreed consideration, even if it was of little or no value. The decision was based on the principle that once the agreed consideration is provided, the contract cannot simply be reversed on the ground of repudiation. So according to the contract here, the infants cannot repudiate. But then the court, obviously, what I think the court would actually be looking at is that is a form of part payment. It made part payment, was not even a full payment. Although the part payment may not have covered, the 12 weeks that they had used may not have covered the part payment, but then he has received consideration. So the school of thought of it being unfair is that he hasn't used all of it. An infant can decide to change their minds at any time. Anyway, that is for you to consider. Okay, that is it for the effect of repudiation. Let's now look at contracts that are formally valid only when ratified. Okay, we have something called ratification, that they can decide to say, oh, after attaining some certain age, they can decide to want to go ahead with the contract. So at common law, this class of contracts, it consists of contracts which were enforceable by the contract, but which are not binding on him unless he expressly ratified them. So I gave an example of marriage here, okay? So for example, a case of when somebody promises another person marriage. When they attain the age of majority, they can decide to repudiate. They can decide to ratify, sorry. They can say, oh yes, I will go ahead with the marriage. So in the case of Uboman and Mora, the defendant was engaged with the plaintiff for 10 years, all right? And afterwards, the plaintiff decides, the defendant decided to marry another person. Okay, so it was held that the thing about it was that the defendant was claiming that he entered into the contract when he made the promise of marriage when he was underage. But then it was later discovered that he also promised the plaintiff when he attained the age of 20. After like 4 years, all right? When he was already 24 years, after 4 years of that agreement, obviously he has attained majority. When he attained majority, he also has promised that girl again that don't worry, I'm going to marry you. But he went ahead to marry another person. So in this case, he has attained majority when he promised again after 4 years. So it was agreed that he has ratified. And so he more or less, he has breached the contract of marriage. So that is for cases of when the case a case can be ratified, a contract can be ratified. We also have contracts that are seen as absolutely void. Contracts that are absolutely void. They are contract of loan. An infant cannot get a loan, should not be given a loan. An infant cannot contract for goods that are not necessaries. You know, that are not necessaries, and also goods that are not for his beneficial contract of service. All right? Those goods are not to be contracted for. And so immediately he contracted for those goods, it will be seen as void ab initio. Also, for account stated, for example, an infant borrowed an account, an infant's money, and after the infant, or you lent an infant money, then you wrote, there's an IOU that I wrote for you that I will be paying you, I owe you this certain amount of money, and I'll be paying you. That IOU will not be regarded and will not be approved under the law. So in the case of the Jones, it was held that an infant could not be made bankrupt on the petition of a person who had supplied him with goods on credit for trade purpose. Remember also the case of Abake and Abinjo, all right? So it was held that all these things, they are void, and so he cannot pay for the debt that he owed during that time of buying the items. He didn't pay, he bought it on credit, and so he's not due. Because you cannot place something on nothing. That contract was void ab initio from the onset. You cannot be claiming for what is not. Okay, also in the case of courts against Brown-Lakey, the guarantor of an infant loan were held not to be liable to pay the contract or guarantee anymore. In this case, the guarantor were said not to pay the money they have guaranteed, because even in the first place, the infant was not supposed to have been loaned the money in the first place. All right. So in the case of Valenti and Canali, an infant was not allowed to recover the money spent on goods after he had, in fact, used them for some time. The decision might, however, have been due to the fact that the furniture came together with the lease of a property. Okay, so in that case, remember that furniture will not be seen as necessary. But then the fact that he leased an apartment will be seen as something that he can repudiate, is voidable. And so in this case, he was not able to recover the money that he used for because ordinarily, he leased the apartment with the chairs. And so there's no possibility of them dividing it and all of that. They're saying that, trying to differentiate the fact that lease is different from the chairs. And so the court said he cannot recover the money. So since the law on infant contract are designed to protect him against unscrupulous adults, infants are in effect in a privileged position in contractual transaction vis-a-vis adults. So even with regard to contract absolutely void, the infant are only void as against they are only void as against the infant, but they remain binding on the adults. So if an adult contracts with an infant, you cannot claim against the infant, but the infant can claim against the adult. However, when an infant sues an adult for the specific performance of an absolute void contract, the court will deny him this remedy because it will not be mutual, unless, of course, the infant has already performed his own part of the contract. All right? So I'm giving you an example now. If an infant enters into a contract that is void, all right? For example, a contract of goods that are not necessary, but they have done their part. Maybe they have paid consideration. If they claim that you give them those items, they can claim that you give them those items. But in places where they have not done their own part, they have not done anything, the infant cannot claim for anything. All right? The infant cannot claim for the obligation on the part of the adult that the adult should. They cannot claim for specific performance. All right? So let's then look for at liability of an infant in tort and in contract. Generally, infants are not liable under tort. And I gave example of tort. Torts are wrongdoing. Example are false imprisonment, trespass to land, conversion, slander, libel, defamation. Generally, an infant is not liable under tort. Sorry. They are liable under tort. I repeat, generally, infants are liable under tort. Infants are liable under tort. All right, please. Infants are liable under tort. But like we said, they are not liable under contract that are not necessary. But let's now assume that there was a contract there was a tortuous liability that emanates from contracts, especially when that contract is not of necessary. The infant will not be held liable. The infant will not be held liable. And in the case of Jones and Payne, an infant obtained a loan by false misrepresentation. It could not be held liable for deceit. Okay? So he borrowed money. But when he borrowed the money, he gave them, he falsified his age. In that case, it was held that the infant is not liable. All right? Also, in the case of Jenny against Rondell, where an infant was hired a horse, hiring horse is not a necessary. All right? So when he hired the horse, while riding the horse too hard, of course, he was seen to have been negligent. Of course, maybe something had happened to the horse. They now sued her, or he sued the infant for negligence. It was held that in the first place, hiring a horse for an infant is not necessary, and so is not binding on him. It was void from the beginning and is not held liable. But in the case, an action in tort may succeed if the tort is not directly connected to the contract. So if the tort is not directly connected to the contract, if it's a different tort, a different contract, then the infant will be held liable. Okay, so do not forget, under tort, an infant is liable. But if it is connected to a contract, if the torts emanate from a contract, then the infant will be held liable. Sorry, then the infant will not be held liable. I'm sure I'm not tired, right? The last thing we are looking on we are going to treat under the last subtopic is the equitable doctrine of restitution. And now comes to mind is that we are saying that when an infant borrowed money, that it is void. And so they cannot sue them to recover the money again. Is it fair? Is it nice? Then if it is not nice, what has the law been doing? The law has tried to use the equitable doctrine of restitution. And we all know what restitution means. Restitution means giving back what you took out of fairness when you have repented, when you are seen to have been a good person, returning back all you have taken. Okay? So doctrine of restitution comes in different way. For example, fraudulent possession of goods. If an infant still possesses a fraudulent obtained goods, they will be compelled to return it. So if an infant fraudulently, for example, remember our case where where an infant bought an item fraudulently, where he falsifies his age in buying the item. Maybe they falsify their age and say they have above 18 and they bought an item for trade or anything that is not necessary. If the item is still in their possession, it can be recovered from them. Number 2, sale of fraudulent goods. If the goods have been sold, the court may hold the infant accountable for the proceeds of the sale. Please take note of may. May. It's not absolute, okay? It's not absolute. The court may hold the infant accountable for the proceeds of the sale, as in the case of Stoke and Wilson. However, these have been criticized for indirectly enforcing void contract. So it has been criticized that, but when you say in the first place that it should not be sold those items, it is okay when those items are still in his possession. Let's take the items. But if he has sold the items, initially, the items is a void contract. So there's a question as to going back to take something from where nothing existed in the first place. So that has been the contention. So when you are answering this kind of question in exams, all right, in as much as, remember the issue of may. So you should also include may, that they may recover and they may not be able to recover. All right. Okay. So the third one, fraudulent loan of money, where somebody fraudulently falsified their age to get loan. Where an infant fraudulently obtained a loan, the court ruled that the lender cannot recover the money unless the exact money still remains in the possession of the infant. I really don't know how that can happen. But if it happens that an infant loan money from somebody and they still have the exact money, it must be the exact money. And you should be able to know your money before you can say, this is my money and I want to recover my money. Also, there's been criticisms as to regards that. So there has been argument that infants should be accountable for fraudulent activities. Although there have been loopholes, but then there's been equitable doctrine. The doctrine of restitution should allow recovery of equivalent amount of money that was fraudulently obtained, all right? Even if it's mixed with other funds. Like the earlier one that says, if it has been mixed, if it's another money you see from me, cannot take. But we have this equitable principle that says that in cases of fraud, it ensures that infants are not unjustly enriching their own by misrepresenting them, by misrepresentation. However, the rule only appears where fraud is evident. So in the case of where there is fraud, where an infant has fraudulently obtained something, then equity comes to the aid of the person that they have obtained that thing from. Equity says that you can collect it from them because they got it from fraud. And so they should not be enriching themselves from fraud. That takes us to the end of infant capacity. So let's look at capacity of a lunatic. So there are people of unsound minds. So under the law, contract concluded by a lunatic or a mentally disordered person is classified into two categories. We have contract of necessaries and we have contract for other things. Contract for necessaries and contract for other things. For contract of necessary, a mentally disordered person or a drunkard is bound like any other person, because these are necessaries for them that will make them a better person. Okay, so under Section 2 of the Sales of Goods Act, it provides that when necessaries are sold and delivered to a person who by reason of mental incapacity or drunkenness is incompetent to the contract, he must pay. See, you know, when you are looking at the law, you have to look at the terms that are used. The word here says must. He must pay a reasonable amount of money. He must pay a reasonable price. Okay, so as we have seen above, that necessary means goods like food and all of that, that will better the condition of life of a person. Immediately that thing has been delivered, and I want you to also take note of delivery. It must have been executed. So in the place where it has been executed, okay, they have to pay. So a mentally disordered person, the liability therefore arises from their contract, quasi is contractual as of their contract. So an equitable, this is an equitable remedy, that equitable theory that says that an obligation to compensate or restore a benefit conferred on another unfairly in the absence of an express agreement to do so, usually to avoid the receiving party becoming unjustly enriched by the benefit conferred by the giving party. So in essence, when an insane person and an unsound person entered into a contract, he must be strict to the contract, especially contract of necessaries. You do not review it. You should not, an insane person should not be enriching their pockets at the expense of somebody that has been nice to them to give them all of that, okay? But then there's another thing to this thing. There are times that persons of unsound mind, they come to you and you just want to give them something. And so they came to your shop, a person said, oh, he came and said, oh, don't worry, you don't have to pay. And so they gave the person food of maybe what 5,000 naira. After he finished eating, he brought out his wallet and was now counting like up to 100,000. And at that time, we cannot charge up and say, the food you ate, bring the money. Because the intention was for you to give to them before. It was not to sell. So the intention also matters. If your intention was to give them, you cannot sue them for not paying. All right? But if your intention, the agreement was to pay, so be it, they pay. So when the goods are not necessary goods, the mentally disordered person is also bound by his contract as well. But if he can prove these things, if he can prove that owing to the, if he can prove that owing to his mental condition, he did not understand what he was doing, and that the other, and if he can explain that to the court, if he can actually say, oh, while I was buying these non-necessary goods, I was not in my good sense at that time. If he can prove that, then it will not be binding on him. Or that if he can also prove that this other person, when I was buying this thing from them, he knows that I was not in good condition, he knows I was not mentally okay, then it will not be seen to be capable of buying those items. So where a person is suffering from mental disorder, contract made by him during lucid interval abiding on them. And so I want you to also understand that the fact that people are of unsound mind doesn't mean they are totally unsound. There are times that they have lucid interval. That is time that they are stable. So if it was the time that they were stable, that they entered into a contract, that contract will be binding on them, no matter if it is necessary or not necessary. So, ratification of earlier contract made during lucid period. All right. So when a contract is made when the person was not stable during their unstable condition, they can ratify it when they are lucid. When they are okay, they can ratify such contracts. Excuse me, please. Okay, so for control capacity of drunkenness, a person in a state of drunkenness or intoxication is in a similar situation to a mentally disordered person. All right, so you treat their case in the same way. So if they enter into a contract in such a state of intoxication that he did not know what he was doing, and the other party was aware, then the contract is voidable. The contract is voidable at their option. So when they become okay and they are not drunk again, they can decide to ratify it. But where they don't ratify it, the contract will not go ahead again. Now, In the case of the drunken person, so a drunken person can ratify the contract when the effect of their drink has worn off on them. So in this case, there's a proof that the other party to the contract was aware of the drunken person's condition seems hardly necessary. That is, if you want to go to court, the proof that you know the condition that this person was mentally this. So if you want to prove your case in court as regarding the fact that this person was intoxicated or not, and this person was drunk or not, it's easily, you know a person that's intoxicated. Anyway, I want to assume that you should be able to know a person that is intoxicated. And this will take us to the end of the class. I'm going to send the question through your classroom. Expect it before the end of the day. Have a wonderful, at least by then you would have been done with listening to the class.